Justin Trudeau's prorogation of Parliament has been called unconstitutional by many, and the Federal Court of Canada has finally agreed to hear all about it in February. Let's have a look. Welcome back to the channel, and today I've got some exciting news. If you've been following Canadian politics lately, you know that Trudeau has prorogued Parliament, and that there was a legal challenge to that prorogation by the Justice Centre for Constitutional Freedoms. Now, most importantly, they applied for an expedited hearing so that this challenge could be heard in court, which could bring the prorogation to an end long before its expected expiry on March 24th. And the court actually granted this expedited hearing. This decision was regarding the motion to expedite. So to be clear, this isn't a decision on whether or not the prorogation itself was illegal or to be overturned, but instead this is a decision on whether or not it's appropriate to hear the challenge urgently or to relegate it to the normal timeline of other judicial reviews. And that could end up taking years. And I've been rather critical of the courts in Canada on this channel, but for once, this decision appears to be pretty much entirely good news for Canadians. And we're going to start at the bottom with the decision. So Federal Court Chief Justice Crampton concluded that, given the findings and conclusions set forth above, this motion will be granted. And this motion being the motion to expedite. In brief, the factors that weigh in favor of expediting the hearing of the underlying application include the urgency of the matter, the fact that the core relief will become moot if the court's standard timelines are not abridged, and the public interest in having the serious issues raised in the application determined as expeditiously and reasonably as possible. I recognize that it would also be in the public interest for the parties and the interveners to have more time to prepare their submissions, and for the court to have the benefit of those submissions. However, I find that there is a counter-availing and greater public interest in having the serious issues raised by the applicants determined in time to preserve the possibility that Parliament be in a position to address, for a meaningful period of time prior to March 24th, 2025, the, quote, grave challenge, end quote, that the threatened 25% tariff poses to Canada. Now, that grave challenge referenced by the Chief Justice is actually kind of funny, and we will get to that. But first, the Chief Justice ordered the following timeline. This order was issued on January 18th, and it gives both parties just a couple days for each stage of the process leading up to the judicial review, but ultimately it will be held on February 13th and 14th. On one hand, that is kind of frustrating, since that's still almost a month away, but also if you take a look at the timeline, it would be pretty tough to realistically get it any shorter than that if we're being fair here. As for when we can expect a decision from that judicial review, that is also addressed in today's decision. Because part of deciding whether or not it's appropriate to grant a motion to expedite also requires the court to consider whether or not there is any practical reason to do so. If it is not possible for the court to grant a remedy to the situation, even if the court is to rule in favor of the applicants, or at least in our case, to overturn the prorogation, then the decision to expedite is moot and cannot be granted. Which makes sense. Like, having this case jump to the front of the line ahead of other cases makes no sense if there's no possibility for the court to do anything to solve the problem at hand. Which means that the court believes it will be able to have a ruling before March 24th, when Parliament would otherwise resume. And not only that, but it believes that it will be able to make a ruling early enough to make a meaningful difference to the situation at hand. And Chief Justice Crampton had this to say: I accept that it will not be possible to schedule the hearing of the application in time to potentially recover the first of those 3 weeks, while at the same time ensuring that the proceedings remain fair. And those 3 weeks are January 17th to February 14th. However, it is possible to schedule a fair proceeding that will preserve the possibility of granting the relief sought by the applicants in relation to the other 2 weeks, namely the weeks of February 24th and March 17th. If Parliament were to resume its functions for even one of those weeks, that would provide a meaningful opportunity for it to debate the threatened 25% tariff, pose questions to ministers, and otherwise fulfill its constitutional role. Now, personally, I don't actually think that returning by March 17th provides much of a meaningful difference to the otherwise natural end of the prorogation on March 24th. But such a ruling could hurt the Liberals' chances in the upcoming election. However, if we have a ruling ordering Parliament to return before February 28th, or even as early as February 24th, as the Chief Justice indicated, then things could get pretty interesting pretty quickly in Canada. As far as how likely it is for us to receive a ruling which would end the prorogation, this motion to expedite actually contains some glimpses into that as well. It is established by the applicants that even the Liberals ought to consider these tariff problems a grave challenge, which should be taken extremely seriously. And this was said openly by former Finance Minister Chrystia Freeland in her resignation letter. Her resignation from cabinet is the gift that just keeps on giving. Chief Justice Crampton also made a point of saying that whether or not Parliament can actually be of any help in this situation is largely irrelevant, as the applicants are merely seeking to restore that opportunity for Parliament. Now that may sound a little disappointing to most people, and even to me, since it's fairly self-evident that this prorogation was done for political reasons in order to avoid a non-confidence vote. So if a non-confidence vote is to be had on the day that Parliament returns, that might actually hurt the applicant's case, since calling for an election would dissolve Parliament, thereby hindering the reason for the court to overturn the prorogation. But Chief Crampton also had this to say. There is no evidence currently before the court regarding potential for this meaningful opportunity to be negated if the potential non-confidence motion referenced by the respondent, and in the application, succeeds. As noted at paragraph 29 above, the possibility of such a non-confidence vote being brought immediately upon any potential reopening of Parliament prior to March 24th is not something that the applicants raised in this motion. And that is this motion to expedite. Nor did they address the potential implications that the Prime Minister's intent to resign may have for possible future confidence votes. If the respondent is correct that the government has the confidence of the House of Commons, then the meaningful opportunity described above would not in fact likely be eliminated by a non-confidence vote. So here the Chief Justice is basically saying that if in fact Trudeau didn't prorogue Parliament to avoid political trouble, and if in fact he and the Liberals do still hold the confidence of Parliament, then resuming Parliament in order to deal with the grave challenge posed by Trump's tariff threats should be a completely reasonable thing to do. Now, Chief Justice Crampton doesn't say this outright, but it simultaneously implies something else. If the respondent were to attempt to argue against the resuming of Parliament on the grounds that Parliament would dissolve into an election, and therefore proroguing is the best thing to do for Canada in order to let the government deal with Trump's tariff threats, then that would be an overt admission that Parliament was prorogued for political reasons in order to avoid a non-confidence vote, which the applicants are alleging is not constitutionally permissible in our democratic systems. So even before the judicial review has started, it appears the government's reasoning is already boxed in, which is a huge boon for Canadians seeking an early election. That being said, the judicial review is still a month away, and lots can happen between now and then. So we best not count our chickens before they hatch. Plenty of evidence and affidavits will come forward which will shape the conversation in court in a rather definitive way, and the story will very likely change significantly between now and then. We might not get the ruling that we want, and even if we do, there is no guarantee that we will get it when we need it. And frankly, I even half suspect the court will intentionally delay its ruling in order to wait for the Liberal leadership race to conclude on March 9th. But it's also technically not impossible to receive a ruling even before anyone leaves the courtroom on Valentine's Day. Now, for a decision this important, that's actually pretty unrealistic, but here's to hoping that we get a decision at least before the end of February. My preferred outcome would be to have Parliament resume before the end of February to ensure that a non-confidence vote could happen while Trudeau is still Prime Minister. Now, regardless of who takes the reins after he's gone, Trudeau should be the one to suffer the embarrassment of the Liberals not even making official opposition in the next election. For those who are wanting to learn more about this ongoing legal challenge, be sure to check out the Justice Centre for Constitutional Freedoms. They already have multiple videos up on their progress until now, and they will certainly keep people updated as the legal battle continues. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.